As Ramin introduced me, I'm a partner in the law office in Warsaw, in Poland. I deal with criminal matters like on an everyday basis. That's my main practice, and in fact, the sole practice with criminal law in different aspects, like white-collar crimes, but also this true criminal cases, where probably the procedural guarantees that we are going to discuss today are sometimes at least more important than in white-collar cases. Still, the main issue that we are going to discuss today is the recent case of the Court of Justice of the European Union, in the light or referring to regarding the directives concerning procedural rights in criminal proceedings generally. So it will be a difficult task because we have to go through a few cases, and now we will focus on the cases mainly, discussing briefly the merits of the case in a sense of factual circumstances, so to understand what was the problem in specific case, and then discuss the conclusion of the court. But to make it a little bit probably more practical, I also prepared kind of interludes in the meantime that will be just information on the implementation of the particular directives, only the main conclusion of the European Commission, who was analyzing how it went in different member states. But before we will go to the core of the presentation of our meeting today, let's see what we are in fact thinking of when we are talking about procedural right in the European Union law. So with what kind of directives we are thinking of, we can think of. There are a few, as you see. All of them are directives, so there are legal acts that are binding as to the goal they set up. But the ways they are implemented is chosen by each and every member state. So we have the right to information, we have the right to interpretation and translation, we have the right to have a lawyer, the right to be presumed innocent and to be present at trial, so mainly the basic procedural safeguards. We also have more specific special safeguards for children suspected and accused in criminal proceedings. And last but not least, the right to legal aid. As Ramin mentioned, we will focus on 4 of them, mainly the first 4. So right to information, right to interpretation and translation, right to have a lawyer, and right to be presumed innocent and to be present at trial. As I said, directives set up only the goals. So in fact, the minimum standards that refer to each and every topic I mentioned. These rules are very simple, very basic. Mainly the core part of each directive is only a few articles, around 10, let's say, which set up basic rights that probably for each and every citizen in the European Union seems to be something that is obvious, that shouldn't bring any questions, that should be just there at the table when a citizen is facing criminal proceedings, because they are of very basic nature. That's why they are in fact a cornerstone of the mutual trust of the European cooperation in criminal cases. Basically, they build trust, belief that everyone has the same rights in every country, and if moving freely around Europe, he or she, the citizen, will just have troubles, she has belief that they will end up with a package of basic rights that constitute just a fair trial. So if they are so basic, what problems we can in fact have with them? As a practicing lawyer, probably you are fully aware that it's not so simple in practice. So let's see what the report states, what the case law shows, what kind of problems they shows. So right to interpretation and translation as a first. The general conclusion of the report states that, however, the directive impact is limited to setting minimal rules consequently leaves possibility for different between national criminal procedural laws. It does impose clear obligation on member states. But what's more important, the assessment has risen certain issues of compliance in several member states, in particular for communication between suspect or accused person and their legal counsel, the translation of essential documents, and the cost of interpretation and translation. As you see, these problems that are mentioned here are probably the basic rights, the basic aspects of right to interpretation translation that you would think of when thinking about this particular procedural safeguard. And if we look on the right to information, the report states that the evaluation highlights that there are still difficulties regarding key provisions of the directive in some member states. Particularly, in several member states, the problems are with the letter of rights in criminal proceedings and European arrest warrant proceedings. So letter presenting basic information about the rights in criminal proceeding particular state. And the right to information about the accusation, the right of access to the materials of the case. So as you see, again, there are problems in several member states with the very, very basic, issues, very basic rights provided by this directive. And now I think that we can go to see a few cases which refers to those two issues. So right to information and right to interpretation and translation. So we have quite recent case C242/22, in which a Moldavian citizen was facing criminal proceedings in Portugal. He was generally provided translated documents concerning the charges he was facing, but he was also asked to fill in the statement of identity and whereabouts, which was not translated. So he was generally asked to put some information about, mainly and most importantly, his address for correspondence. He has an address of residence in Portugal, but the form was not translated to him. He was sentenced for a penalty. The sentence was suspended, but then he received a written request to show up before the police the police station, just to see how the probation period is going on. And unfortunately, he didn't receive this request and he did not appear. And the execution of this suspended sentence was ordered because of a lack of his presence. He was then traveling and he was just detained somewhere a few months later, when the decision to execute the suspended sentence was valid and binding. Of course, being detained, he appointed a lawyer, he appealed the decision and asked to declare this decision concerning execution of the suspended sentence null and void, as he was not informed that he has to be at the address given in the statement of identity and whereabouts. And the Court of First Instance dismissed this appeal, stating that the defects, procedural flaws have not been invoked in the prescribed time. So were invoked in the appeal submitted after the decision became valid and binding. And that was the core problem that the Court of Justice was facing. And the court stated that right to information must be interpreted as precluding national legislation under which the infringement of the rights provided for those provision of those directives must be invoked by the beneficiary of those rights within a prescribed period, failing which that challenge will be time-barred, where that period begins to run before the person concerned has been informed in a language which he or she speaks or understands, first, of the existence and scope of his or her rights to interpretation and translation, and secondly, of the existence of content of the essential document in question and effects thereof. So it was generally stated that if the person does not have any fault in a situation in which he was not aware of the of his obligation. He cannot be punished of the for the fact that that his obligation were violated. He violated his obligation. So the right to have information about his legal situation cannot depend, and the right to be given interpretation translation cannot depend on a deadline that the accused could not have been aware of. So the general conclusion is also that the right to interpretation, in fact, any rights of the directive, if we look at the jurisprudence of the court, are in fact absolute, even there is no fault on the side of the accused person. So generally, it was stated that it didn't matter that the defects of the proceedings were raised by him after the prescribed time, because he was not properly informed about his rights. He was not given proper translation interpretation wholly. So also with regard to the statement that in fact brought the most important obligation in his situation. And then we have another case concerning the right of interpretation with regard to the quality of this interpretation, and in the same time, right to information with regard to letter of rights and right to information about the accusation. So as you see, this judgment C564/19 refers or proves that the conclusion of the European Commission when analyzing the state of implementation of the directives are in fact true. In this case, we had a Swedish citizen of Turkish origin facing criminal proceedings in Hungary. And before the questioning, this suspect was requested the assistance of a lawyer and interpreter. And during the questioning, which the lawyer was unable to attend, he was informed of the suspicions against him. He refused to give any statement on the ground that he could not consult his lawyer. However, there was no information as to how the interpreter was selected and how the interpreter's competence was verified, or whether the interpreter and the accused understood each other. And that was the main concern of the court when dealing with the case of this accused person. Mainly because what the court stated in the question to the Court of Justice, Hungary doesn't have the official register of translators and interpreters. I'm not aware how it works in each and every member state. I can tell you that in Poland, we have the official register. However, it's also possible to appoint a so-called ad hoc interpreter. So the interpreter that is appointed as a sworn interpreter for the sake of particular activity, procedural activity, particular, not even case, but particular activity, so interrogation, for example, because there is no sworn translator available at that time. And in fact, I also faced such situation lately in Poland, where such ad hoc interpreter was appointed, and also the problem of adequate quality of such translation appeared at this interrogation. But getting back to the case, the court stated that right to interpretation of adequate quality must be interpreted as imposing an obligation on member states to take specific measures to ensure that the quality of the interpretation and translation provided is sufficient for the suspect or accused to understand the accusation, and that this interpretation can be reviewed by national courts. So it's not only about providing right to interpreter. The member state must provide proper interpreter, an interpreter reading between lines that speaks the language that is understandable for a defendant, and that speaks language on a proper level, giving guarantee that all important information will be understood by the defendant. It, of course, requires not only knowledge of everyday language, but also knowledge of the very specific language, legal language, and that all will sometimes brings problem. In my case, I refer to, and my client was a Romanian citizen, and the interpreter, the ad hoc interpreter that was appointed for this case, was a policeman working in Poland, in Polish police, that had Moldavian roots. And unfortunately, he was not able to speak Romanian fluently, but he was aware of Moldavian language. That is kind of one of, let's say, of the historic version of Romanian language. So in fact, even I was knowing basic information about the client because it was arrest proceedings just after the transfer of a person on the basis of European arrest warrant. But I already had some basic information about my client, and I was even able to note that the translation is not proper. The court did not take any measures. The court was arguing that I'm not fluent in Romanian or Moldavian, so I'm not able to verify the translation that was going on, and did not do anything with this interpreter. Of course, the client also raised questions concerning the interpretation. It was a recent situation, so unfortunately, I do not have any information how it was or will be dealt with by the Court of Justice. But that just proves that that situation are not unique and individual. But with regard to this case, as I said, it also refers to the right to receive letter of rights, a letter to information about the accusation. And the court stated that it must be interpreted as precluding a person from being tried in absentia, while due to inadequate interpretation, he has not been informed of the accusation in a language he understands, or where it's impossible to establish the quality of the interpretation provided, and thus to establish that the person has been informed of accusation in a language he understands. Because the suspect in this case left country after interrogation. So there was also a question if he was really properly informed about the accusation, about his rights and obligation, if the translation most probably was not of the proper quality. And then we have also another case that refers to the defects of the indictment, that refers mainly to the right to information about the accusation. It's specific case as it regards the specific regulation according to which, if the defects of the indictment were defined after the preliminary hearing, it cannot be referred back to the prosecutor. So any defects of the indictment that was in this particular case defined by the court at the later stage of the proceedings, they were of the quite serious nature in the opinion of the court. And in the opinion of the court, in fact, the proper solution would be that the indictment would be returned to the prosecutor. But according to the national regulation, it was not possible to do that, and the court was obliged to do it on its own. However, it was changing, in the opinion of the courts, the charges significantly. So the court referred to the Court of Justice, and the court stated that right to information about the accusation must be interpreted as, firstly, precluding national legislation that does not provide for a procedure that allows for removal after a preliminary hearing in criminal case of inaccuracies and deficiencies of the contents of the indictment that result in a violation of the accused person's right to receive detailed information about the charge. So, in fact, the court stated that the accused person must be aware fully about the scope of accusation at the beginning of the trial. So it refers to the literal meaning of the articles of the directive concerning right to information, which states that this information must be before the case is put before the court. And secondly, the Court of Justice stated that right to information about the accusation must be interpreted as meaning that the referring court is obliged to interpret to the fullest extent possible a consensual interpretation of national legislation on the amendment of the indictment that would allow the prosecutor to remove during the trial inaccuracies and deficiencies in the context of the indictment, while ensuring active and effective protection of the accused person's rights of defense. Only if the referring court finds that a consensual interpretation in this sense proves impossible, should the court refrain from applying the provision of national law that prohibits the suspension of court proceedings and return of the case to the prosecutor for a new indictment. So the court gives a hint what to do in case there are problems with national law that may be somehow infringing the rights provided in directives. The court generally said that the national court must try to find a most proper interpretation of law before stating that it is not applying particular national provision. And then we have quite interesting case of a Polish citizen in Germany. He was a heavy good vehicle driver, and that was banned from driving a car in Germany due to some small things. The order was delivered, the order refraining him from driving a car was delivered to a person authorized by the accused to accept service of documents. It was an official at the local court. The form of the power of attorney for this official did not include any details regarding the legal and factual consequences that authority to accept service, in particular concerning any duties on the part of the accused person to seek information from the person authorized to accept service on his behalf. So this accused person just gave the authorization to this official to accept service of the final sentence, but there was no information if this accused person has to contact this official individually to get information about the sentence or not. So it was not clear for accused who was responsible for giving information to him about the final sentence. Moreover, in this case, it was not possible to determine whether the letter that was sent by this official was received by the accused, and the case started when the driver was stopped again by the German police while driving a car within the time of ban from driving a car. And the question of the national court referred to the right to information about the accusation. And the court stated that the right of information about the accusation does not preclude legislation of the member state under which the 2 weeks period for lodging an objection against an order which has been imposed begins to run from the date on which that order is served on the person authorized to accept service on that person's behalf, provided that as soon as that person becomes aware of it, he actually has a period of 2 weeks to appeal. So generally, the problem was if this person, if the driver was aware that he was banned from driving a car in Germany, and the court stated that it is possible that the period for lodging an objection is 2 weeks, but it must be counted from the time the driver, the accused, really became aware of the sentence. So the court stressed the fact that right to information must be actual, factual, that the accused person, sentenced person, must be aware of what is going on. And moreover, the court stated that the right to information precludes legislation of member states under which a person residing in another member state incurs a criminal penalty if from the date on which it acquires the force of res judicata, that person does not comply with an order which has imposed a driving ban on him, even though that person was unaware of the existence of that order. So it was kind of sequence of the first answer, stating that it cannot be in a way that the person is not aware that he is banned from driving a car, and must incur the consequences of such decision. And one of the most recent cases, because it was issued at the beginning of September, that brings a few problems. First problem that we'll discuss here is remedies of the infringement of rights provided in the directive concerning information, right to information, but it can be also referred to any, in fact, directive. And in a moment, we'll also refer to this case in another aspects concerning problem of definition of a suspect and accused, and right to access to a lawyer. So the car was stopped in Bulgaria, and before the driver of the vehicle was tested for drugs and alcohol, two persons that were in the car told police officers that they had narcotic substances in their possession. The notification was made by made to the nearest police station, and the search was ordered without any written decision. And then the court was asked for confirmation of the search. Of course, during the search, the substances were found. It was recorded in the protocol. And of course, none of those two persons had any access to a lawyer. And as I said, the request for confirmation of the search was sent to the court after the search was conducted. I assume that it's a situation that's possible on the in many different countries. That situation for sure is possible. Such situation is for sure possible in Poland. So the question is, if the verification and remedies of the infringements of rights provided in the directive must be immediate. That's in fact the question. And the court said that the right to verification and remedies of the infringements of the rights provided in the directive must be interpreted as not precluding national case law, according to which a court sized under an applicable national law, of an application for retrospective authorization of a personal search and the subsequent seizure of illegal substances carried out during the preliminary stage of criminal proceedings, does not have jurisdiction to examine whether the rights of the suspect or accused person guaranteed by those directives were respected on that occasion, provided, firstly, that that person is able subsequently to establish before the court hearing the substance of the case any infringement of the rights arising from those directives, and secondly, that the court is then required to draw conclusion from such an infringement. So the verification and remedies of any infringements of rights provided in directive concerning right to information, or in fact, in my opinion, we can apply this rule to any directive concerning procedural safeguards, of course, must be retrospective, but only if, in fact, the court will have chance not only to analyze if this infringement took place, but also to draw appropriate conclusion. And then we go to the issue of access to a lawyer. As I'm running out of time a little bit, I will just indicate shortly that also with regard to access to a lawyer, there are problems with implementation with regard to basic issues. And we will go through with this case, so C209/22, so concerning the search, with regard to the right to access and to the definition that is very basic for each and every directive concerning procedural rights. So the definition of suspect or accused person, because in Bulgarian law, there was no definition of an accused, of a suspect. So the court was thinking if it really has opportunity to apply the directive properly. So the Court of Justice stated that suspects or accused person in criminal proceedings must be interpreted as meaning that those directives apply to situations in which a person, in respect of whom there is information to the effect that he or she is in possession of illicit substances, is subject to a personal search and seizure of those substances. The fact that national law does not recognize the concept of suspect and that that person has not been officially informed that he or she is an accused person is irrelevant in that regard. So in fact, the court stated between the lines that even in that situation, that there are no formal charges or there are no formal definition of suspect, or probably if that would refer to accused person, that would also apply. The rights should be given. The person is authorized to ask for such to ask for execution of the rights provided in directives. And then we have the issue, of course, of right to access to a lawyer in criminal proceedings. And the court in this regard stated that, of course, as the situation was immediate and the situation did not, in fact, somehow even made possible to call a lawyer, it's possible to proceed in such a situation with the search. However, there's one condition, that the person that was searched would be able to exercise his or her rights of defense practically and effectively. So it was up to the court to decide if in the circumstances of the case, these two persons who claim that they have illicit substances had really possibility to exercise their rights of defense. And then with regard to the right to access to a lawyer, we have case 347/21 concerning both the access to the case and, in fact, also the right to be present at the trial. So it touches also the issue of trial in absentia, which will lead us to the last directive that I want to discuss with you today. And the circumstance of the case was that at the initial hearing, both the accused person and his lawyer appeared. But before, and of course, took active part in the interrogation of the witness. Before the next hearing, the lawyer asked to adjourn the hearing on the ground that he had not yet recovered after contracting the coronavirus. At the hearing, the accused person appeared and requested that the proceedings should be adjourned due to the absence of his lawyer. But the court proceeded with the examination of the witness. Another court hearing, the next court hearing, was conducted in the absence of both the accused and his lawyer. When finally, at the next hearing, the accused person and his lawyer appeared, they had opportunity to interrogate witnesses that were heard in the absence of the lawyer, or both of them, in fact. And the court assessing the case had only one problem. If the fact that they were given chance to ask questions was enough, or if the examination of the witnesses heard in the absence of one of the accused persons and his lawyer should be repeated fully, so the other parties of the proceedings should also repeat their questions. And the court stated that right to be present at trial or right to have access in criminal proceedings must be interpreted as meaning that where, in order to ensure that the right of the accused person to be present at the trial and the right of access to a lawyer are safeguarded, the national court carries out an additional examination of an incriminating witness, since for reasons beyond their control, the accused person and his lawyer could not be present at the previous examination of that witness. It is sufficient that the accused person and his lawyer be able freely to question that witness, providing prior to that additional examination, the accused person and her lawyer were sent a copy of the minutes of the previous examination of that witness. In those circumstances, it is not necessary to repeat in its entirety the examination. So the court said that the right to be present, the right to have a lawyer, would be executed in case they have opportunity to ask questions. The full repeat of the examination is not necessary in such situation. And then, as I said, we smoothly go on the basis of this, in the light of this case, to the last directive, providing generally the right to be present at the trial and right to be the right to the presumption of innocence. My apologies. And generally, if you will read later the main conclusion of the analysis of implementation of the directive, you will see that again there are problems with very basic rules. The directive in itself provides, in fact, those two rights, and the rules concerning burden of proof in the proceedings. And in fact, the case that I want to discuss right now refers mainly to burden of proof issue. To particular, on the basis of the particular provision of Bulgarian law, which states that after a person held in detention the case of person held in detention is referred to a court, the court must first review the merits of that detention, and if that court rules at the beginning of a trial, in fact, that the detention is lawful, the detention continues for an indefinite period of time and is not subsequently re-examined of the court's own motion. So the detention lasts as long as a person held in detention proves that that there are new circumstances justifying his release. And the Bulgarian court asked if this rule is compliant with the burden of proof rule provided in the directive. In a sense, in the light of the fact that it's on the accused person and his lawyer side to prove that there are changes of situation that enable change of decision concerning pretrial detention. And the court stated that the rule concerning burden of proof do not apply to a national law that makes the release of a person held in detention or remand pending trial conditional on that person establishing the existence of new circumstances justifying that release. So the court generally stated that that's correct, that the fact that that is prosecution's obligation to prove guilt of accused person refers only to main proceedings. And the court referred to the fact that there is a minimal degree of harmonization and that it cannot be interpreted as being complete and exhaustive instrument, that any directive cannot be interpreted as being complete and exhaustive instrument included to lay down all the conditions of the arrest. So in fact, the court stated that the proceedings concerning arrest are not the main criminal proceedings. Therefore, some of the rules concerning the pretrial proceedings may not be the same as in the main criminal proceedings. And that is, in fact, a problem that probably all of you face with regard to arrest proceedings. Not only with regard to the burden of proof, but also in the light of the access to case files. And of course, the directive in this scope also provides regulation that makes it possible to limit the access to the case files at the time the pretrial detention is ordered. But as you know, in practice, it brings many problems. And probably one of the last, because I know that I'm run already out of time, but one of the important cases, the recent cases, providing, let's say, kind of basic information or basic rules, general rules concerning the trial in absentia, that we know that is a very problematic issue on the European level, mainly with regard to European arrest warrants, and probably you discussed that already, but also in national practice too. The case, the circumstances of the case are as follows. Initially, an indictment was served to the accused in person. So the accused received the indictment personally. Following service, the accused indicated the address at which he could have been contacted. However, he was not found at that address when the judicial stage of the criminal proceedings commenced. The court appointed a lawyer on its court's own motion, who did not establish contact with the accused person. The proceedings, however, were discontinued due to the flaws of the indictment. So the proceedings initiated by the indictment at which the accused person was present at the beginning were just discontinued. And subsequently, a new indictment was drawn up, so the flaws were, the defects were repaired, and the proceedings were reopened. The accused was sought once again. The court did everything what it could. So the court contacted members of the family of the accused, the former employers, mobile telephone operators, but he could not reach the accused person. So the court decided the accused has absconded and the case can be heard in absentia. So in fact, the case, the core issue is if the rights are if the rights provided in the directive, particularly directive concerning the presence at the trial, are applicable in case authorities do not succeed in locating person despite their reasonable efforts. And what the court stated? The court stated that the right to be present at the trial and right to a new trial must be interpreted as meaning that an accused person whom the competent national authorities, despite their reasonable efforts, do not succeed in locating and to whom they accordingly have not managed to give the information regarding his or her trial, may be tried and, as the case may be, convicted in absentia, but must in that case, in principle, be able, after notification of the conviction, to rely directly on the right conferred by that directive to secure the reopening of the proceedings or access to an equivalent legal remedy resulting in a fresh examination in his or her presence of the merits of the case. That person may, however, be denied that right if it's apparent from precise and objective indicia that he or she received sufficient information to know that he or she was going to be brought to trial, and by deliberate acts and with the intention of evading justice, prevented the authorities from informing him or her officially of the trial. So generally, Article 8 of the directives set up the condition in which in absentia trial may be conducted, but in the case but generally the right to the reopening or to a new trial must be provided. However, in a case that it's apparent and objective that person officially informed about the charges about the criminal case, generally speaking, takes deliberate steps to avoid receiving any official information regarding the hearing, this right to a new trial may be denied. And the court gives an example of, for example, giving fake address to the investigative authorities, to the court or the police. And in this particular case, the court decided that it's apparent that the person the accused was trying to evade justice. And as we run out of time, I hope that you will be given access to the presentation and have opportunity to look at another case that I was prepared to present to you. But let's go to the summary. So what we know from all these cases that I mentioned, first of all, that even simple rule is not simple enough in practice. So even the simplest sentence giving the right to interpretation, giving the right to access to a lawyer will bring problems in practice. So we have to be very careful in our practice not to miss everything. Secondly, the rights interfere with each other. So we have always tried to have a broad picture, both on national level and international level, I mean, with regard to the reference to the international courts. Then the rights cannot be overused by own negligence fault. But in case no fault is on the side of the accused suspect, the rights are guaranteed, in fact, almost in absolute way. And the rights should be executed from the very beginning, even if there is no formal decision on charges. And this may be only denied in a case when the fact that they are not given in the full scope, for example, may be executed at the later stage and do not bring any problems, any limitation of general right to fair trial. And that's all I presented for you. Thank you for your attention. And of course, if you have any questions, please ask.